We have all heard mention of the famous legal case Plessy versus Ferguson and knew it was significant because we have heard of it. Advocates for civil and human rights brought many cases to the courts as the most peaceful method for change. Some were successful, most were not. Some background. It may surprise some to know that after slavery, blacks enjoyed integration with whites. The bill was first introduced in 1870 by one of Congress's greatest advocates for black civil rights, Senator Charles Sumner of Massachusetts. The original bill outlawed racial discrimination in juries, schools, transportation, and public accommodations. But Republican leaders were forced to clip away all reference to integrated schools in order to get the votes from Democrats to pass the bill. 7 black men served in the 43rd Congress: James Rapier, Robert Elliott, Alonzo Ranzier, John Lynch, Richard Kane, Josiah Walls, and Joseph Rainey. They carried the debate in favor of the bill, offering personal accounts of discrimination on railroads and in restaurants. Representative James Rainier of Alabama said, "Every day my life and property are exposed, are left to the mercy of others, and will be so long as every hotel keeper, railroad conductor, and steamboat captain can refuse me with impunity. After all, this question resolves itself into this: either I am a man or I am not a man." The outgoing Republican-controlled House and Senate passed a weakened version of the bill after removing all references to equal and integrated education. The vote was 162 to 99. The Civil Rights Act of 1875 outlawed racial discrimination in juries, public transportation, and public accommodations, but it was not consistently enforced. Enforcement was realized in some communities and absolutely not tolerated in others. This was a season when blacks and whites were seen in harmony, where the comfort level allowed, traveling, at resorts and seasides, in restaurants and city parks. Testing the law. The year was 1890. The state was Louisiana, and the test was the Separate Car Act, which required separate accommodations for blacks and whites on railroads, including separate railway cars. The plan created by the Committee of Citizens was to violate the law in order to contest it in court. They encouraged Homer Plessy to be the test case. On June 7, 1892, Plessy bought a first-class ticket at the Press Street Depot and boarded a whites-only car of the East Louisiana Railroad in New Orleans, bound for Covington, Louisiana. The committee hired a private detective with arrest powers to be present. They wanted Plessy charged with violation of the Separate Car Act and not vagrancy or some other charge. The scene was set. Plessy took his seat in the whites-only railroad car, and he was asked to vacate it and sit in the blacks-only car. He refused and was immediately arrested by the detective. As planned, the train was stopped and Plessy was taken off the train. Plessy was remanded for trial in Orleans Parish. First trial. In the case of State versus Homer Adolph Plessy, his attorney petitioned the State District Criminal Court to throw out the case on the grounds that the state law requiring East Louisiana Railroad to segregate trains had denied him his rights under the 13th and 14th Amendments of the United States Constitution. Those amendments, they argued, provided for equal treatment under the law. However, the judge presiding over this case, John Howard Ferguson, ruled that Louisiana had the right to regulate railroad companies while they operated within state boundaries. 4 days later, Plessy petitioned the Louisiana Supreme Court for a writ of prohibition to stop his criminal trial. The Louisiana Supreme Court issued a temporary writ of prohibition while it reviewed Plessy's case. In December 1892, the court upheld Judge Ferguson's ruling and denied Plessy's attorneys subsequent requests for a rehearing, claiming that Ferguson's ruling did not violate the 14th Amendment, citing legal precedents, including 2 key cases from northern states. Determined to have their day in the highest court, the United States Supreme Court, Plessy's attorneys filed 2 legal briefs on his behalf. His legal team included Albion W. Turgey, James C. Walker, Samuel F. Phillips, and F. D. McKinney. A word of introduction about Albion W. Turgey. He was born in 1838 in Ohio. He was a soldier in the Civil War, became a lawyer, writer, politician, and diplomat. After the war, he moved to North Carolina and became involved in the Reconstruction activities. He served in the state legislature and was a pioneer civil rights activist. He founded the National Citizens' Rights Association, and he was the founder of Bennett College, a college for Black freed women. Known as an ally of Black Americans, later in his career, Turgey was asked to aid a committee in New Orleans to challenge segregation on railroads, and he litigated what is known as the landmark Plessy versus Ferguson case. Historian Mark Elliott credits Turgey with introducing the metaphor of colorblind justice into legal discourse. On April 13th, 1896, oral arguments began before the Supreme Court. Turgey built his case upon violation of Plessy's rights under the 13th Amendment, prohibiting slavery, and the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." Turgey argued that the reputation of being a black man was property, which by the law implied the inferiority of Black Americans as compared to whites. It was noted that the state legal brief was prepared by Attorney General Milton Joseph Cunningham, a staunch supporter of white supremacy. In Cunningham's 1916 obituary, it noted that he, quote, worked so effectively during Reconstruction in restoring white supremacy in politics that he finally was arrested with 51 other men of that community and tried by federal officials, end quote. Who were the justices of the 1896 Supreme Court? There were 6 Republicans and 2 Democrats. There was Rufus Wheeler Peckham, George Shiras Jr., Edward Douglas White, Stephen J. Field, David Josiah Brewer, John Marshall Harlan, Melville W. Fuller, Horace Gray, and Henry Billings Brown. On May 18, 1896, the Supreme Court issued a 7-1 decision against Plessy that upheld the constitutionality of Louisiana's train car segregation laws. Judge Brown wrote the majority opinion, reasoning that this was not a violation of the 14th and 15th Amendments, and that laws requiring racial separation were within Louisiana's police power, which was the core sovereign authority of states to pass laws on matters of health, safety, and morals. It held that as long as a law that classified and separated people by their race was a reasonable and a good faith exercise of the state's police power and was not designed to oppress a particular class, the law does not violate the Equal Protection Clause. The state could determine what was deemed reasonable. Judge Harlan's dissent was stated in no uncertain terms. He accused his fellow judges of being willfully ignorant on the subject of treating blacks as inferior. He wrote that, quote, "Everyone knows that the statute in question had its origin in the purpose not so much to exclude white people from railroad cars occupied by blacks as to exclude color people from coaches occupied by or assigned to white persons. The thing to accomplish was, under the guise of giving equal accommodation to whites and blacks, to compel the latter to keep to themselves while traveling in railroad passenger coaches. No one would be so wanting in candor as to assert the contrary." End quote. To support his argument, Harlan pointed out that the Louisiana law contained an exception for black nurses attending children of the other race. This exception allowed black women who were nannies to white children to be in the white-only train cars. Harlan said that this showed that the Louisiana law only allowed black people to be in white-only cars if it was obvious that they were social subordinates or domestics. Harlan argued that even though many white Americans in the late 19th century considered themselves superior to Americans of other races, the United States Constitution was colorblind in matters of law and civil rights. It has been stated that this was the worst decision ever made by any United States Supreme Court. Their implicit bias slanted their interpretation of the Constitution and caused unmeasurable harm to all Americans by ushering in a standard of separate but equal rather than addressing racial equality. This was not challenged successfully until Brown versus Board of Education in 1954. Additionally, this put a final nail into the Civil Rights Act until passage of the Civil Rights Act of 1964, which prohibited legal segregation. So, who was Mr. Plessy? To look at Mr. Plessy, you would think you were seeing a white man. He was nearly that. Mr. Plessy was an octoroon, or a person 7/8 white and 1/8 black. By the way, do you think that his heirs would qualify for slavery reparations?